Welcome to Aging in Ottawa, your source of information on what matters to seniors and their caregivers in Ottawa. I'm your host, Bonnie Schroeder. On today's show, we're speaking with Pat Murphy, Counsellor at Law and Certified Senior Advisory. He's legal counsel with the local Alzheimer's Society and the Elder Abuse Consulting Team of the Champlain Lynn. Welcome, Patrick.
Thank you. Grateful for you having me today, Bonnie.
Now, this is an area I will admit I don't know a whole lot about, so I'm hoping I'll learn a little bit here today. So, and we talked about not necessarily going wills one-on-one, so we're going to jump into a lot of this. So how can seniors make wills that reduce taxes, probate costs, and disputes? Because that's a real issue around saving money.
Well, first of all, a lot of lawyers aren't in the field of wills, trusts, and estates. It's not really a very sexy field. If anybody had told me when I graduated as the president of my graduating class a million years ago at Ottawa U that I'd be here with you today talking about death and taxes, I would have said, that's not really what I went to law school for. But it's a very topical field nowadays, just the demographics. You know that there are so many seniors. We're in the biggest wealth transfer in the history of mankind. There's different family relationships. A lot of people are living solo. A lot of people are into second, sometimes third marriages. It's a very rife field. As a matter of fact, I spent the last 2 days watching a webinar out of Toronto. We have an annual Estates and Trust Summit. And I've been watching 24 of the top lawyers in Canada talking about the tremendous changes in the laws relating to seniors planning. I like to call them young seniors, planning their affairs so that they can save taxes, cut down on lawyers' costs, and fulfill their responsibility to their families for not leaving a mess. Most lawyers are taught in law school to do what I call an ordinary will, a will leaving everything to the missus, and if there's anything left over, it goes usually equally to all of the kids. But people now are worth a lot more than they were before. It's not at all uncommon for people probably living within a couple of miles from this studio to be coming into my office in maybe a 7-year-old Toyota Corolla, and maybe dressed down in a golf shirt and jeans, but when I sit down with them, I find out that maybe they're worth well into the 7 figures. And as a result of that, I've created and actually trademarked a process called the family will planning process, whereby it's a step up from the ordinary will that maybe a lot of people's real estate lawyers did for them 15, 20 years ago. That includes wills that save taxes and costs, including testamentary trusts, very powerful, legally valid powers of attorney, and we even recommend that our clients pre-arrange their probate. A lot of people pre-arrange their funerals. We recommend they pre-arrange their probate so that this will keep costs down, fulfill a responsibility to their families, minimize the legal costs, and save a lot of money in taxes.
So what is involved in that process then?
Well, it's a different type of process, and it's not for everybody. And with my clients, I go through the process. Most lawyers will give a free consultation to anybody that comes in. And like lawyers, we have to diagnose before we prescribe. So I'll look at a person's situation. And there's usually about 10 factors that I say beyond the sort of ordinary will that, as I said, the real estate lawyer might have prepared for them 10 years ago when they downsized their house and moved into a condominium or something, that maybe they might want to give a little more thought to. People don't realize that saving taxes and costs in wills is not only something that the Rod Brydens or the Eugene Milniks of the world do. My clients are generally what I call comfortable, semi-affluent people who have a gross net worth. If they both die suddenly, a gross net worth of between 0.5 million and 5 million. And if you're in that range, you should be thinking of a little more than just the ordinary will. We might be able to set up a will with several testamentary trusts in it. I know the word trust makes people's eyes roll, but I've studied them and I'm sort of on top of my game on that. It's not at all uncommon for me to recommend a will to people with several trusts for the surviving spouse, then a separate trust for all of the children. Using myself as an example, I'm very fond of my son-in-law, very, very fond of him. But if he should separate from my daughter, I want to make sure that the inheritance that my daughter gets stays with her and doesn't go to him. And I don't practice family law anymore, but I understand that the family law lawyers have figured their way around a lot of marriage contracts and a lot of other things, but they haven't figured out a way around if I leave everything to my daughter in trust. They can't break that trust, and that's the only way I can really protect that inheritance from my daughter.
Yep.
There are a lot of other aspects to these wills that contain trust. Everybody who's in a second relationship, I think, probably wants their estate after their surviving spouse passes to go to the children that they brought into the marriage. Well, you can't do that with an ordinary will. You can only do that with a will set up with a bunch of trusts. And leaving your inheritances and trusts is just a better way of doing things in the administration of the estates when you get to the other end of it. My clients, for instance, if a client of mine has passed away today and I go back to the office tomorrow, I was literally at a wake for one of my friends last night, and it's refreshing. I'm a little taller than most people to see the widow making her way through the crowd at the wake and coming up to me with that look of terror saying, "Oh my God, what happens now legally, Murph?" And it's nice for me to say, don't worry about it. Come in on Wednesday afternoon with your daughter. It'll take half an hour to sign the papers because George set everything up ahead of time in something I call a comfort book to prearrange his probate. We'll have the probate and the legal matters wrapped up within, are you sitting down? 1 month. And get the lawyers out of there as quickly as possible and get the money in the estate where it belongs with the financial advisor.
Yes.
And that appeals to most people.
Yeah, so what I'm hearing is peace of mind, comfort, making your family members after your passing as easy as possible.
Gets better than that. 16 years ago, a client of mine called me, and on the phone I could tell that he wasn't in very good spirits. Liver cancer. We all know what that means. Pretty well a 6-month death sentence. What can I do for my wife?
Yeah.
To make a long story short, that widow has been saving the better part of $1,000 per month. Do the numbers. 16 years, 12 months, $1,000, just because he set up a will with a bunch of trusts in his will. It continues to get better. When the wife passes away, whatever money is left over, and there's more money left over because of that. She's actually still living in her house in the East End. But there'll be more. The money that goes to the children won't be going to them directly. It'll be going in trust. It'll be going in trust for them, so that not only is their money protected, and again, I'll use my daughter as an example. If she was to inherit $500,000, just to make the numbers easy, under the current law, if she was to invest that, and she probably would, she and her husband are pretty well off, and she would say she earned 4%, again to make the numbers easy. That $20,000 she earned would have to go on top of her salary, and she has a pretty good job, and it would be taxed at the better part of 50%. We pay a pretty high tax rate here in Canada. But if I left that money to her in trust, she could sprinkle that $20,000 she earns to her 8-year-old son and another $10,000 to her 6-year-old son, who are tax-free on the first $10,000. Now, would she rather pay no tax on that $20,000 every year or pay taxes on it every year? So those are significant savings, not to mention the family law savings I mentioned a minute ago. And it would be just an encouragement. I'm not going to tell my daughter how to spend her money. She's sort of bullheaded like her father. But she would be encouraged, shall we say, to keep that money as a nest egg or a rainy day fund, maybe for my beloved grandchildren's education. And we all know that young seniors dote on their grandchildren, and I certainly do in my 6 grandchildren. So the bottom line is that with my 6 grandchildren, the first $60,000 of income on from my will will be tax-free under the current law.
Okay. Well, we'll be right back after this and continue our conversation with Patrick Murphy about legal issues for seniors. Thank you. Oh, you could. Oh, is it? Okay. Okay. Yep. Yep. Makes sense. Excellent. So I'll ask. Welcome back to Aging in Ottawa. I'm your host, Bonnie Schroeder. Today we're talking with Patrick Murphy about wills, powers of attorney, and probate, of all things. I said I wasn't an expert on this, but you've already shared great ways to save money in your wills. So how can what you call young seniors, comfortable young seniors, make powerful power of attorneys that are legally valid? Because you shared that with me. So.
Well, first of all, there's a shocking statistic that I recently became aware of that 71% of people in Ontario don't have powers of attorney. Probably because they don't know what they are and they don't realize how necessary they are. I don't know about you, Bonnie, but I'm much more concerned about Pat Murphy when I'm on this side of the grass than when I'm on the other side of the grass. And I preach control. Control your assets. You don't know how long you're going to need them. Some of us might become centenarians, which I find personally terrifying, but it does happen out there. You don't know when you or some of your family members might need your money. And I recommend that people stay in control of their assets. And the way I recommend they control that is by making what I call, instead of an ordinary will, a family will planning process, which covers these wills with testamentary trust, powerful powers of attorney, which we'll discuss now, and pre-arranging your probate. A lot of people don't realize that most powers of attorney, of the few people that have them, aren't legally valid. I've been told by people that are, my clients are okay, but people on the ground, especially people who have been dealing with these will kit powers of attorney, or the ones you get off the internet from the government, just aren't completed properly, but 45% of them aren't worth the paper they're written on. Of course, most powers of attorney aren't brought into effect until after a person is incapacitated. It's too late to make a new one. So you better make sure that it's done properly in the first place. I don't know about you, Bonnie, but I don't drill my own teeth or fix my own car or operate on my own broken leg. We're in an age of specialization. You have to go to a doctor that specializes in eyes if you have an eye problem, and somebody else if you have a problem with your feet. And similarly with lawyers. I've been in this business for an awfully long time. I used to have a very broad general practice. I do divorce one day, house purchase the next, a corporation the next, but things have gotten so complicated that I focus on wills, trusts, and estates. And you really have to, you're really highly recommended to get a lawyer who focuses on this field. There aren't that many of us in the city of Ottawa that would have sat through that 2-day webinar, for instance, on a holiday, which Monday was for most lawyers. But what a lot of people don't realize is that the power of attorney they make, even the one they might have made 15 years ago with their real estate lawyer, if they bring it to a bank, it's not going to be automatically accepted. As a matter of fact, the bank will strive to not accept it. There are a lot of problems with powers of attorney. If I owe you $20 and give you a $20 bill, you have to accept it. You don't have to accept $20 worth of bananas. You don't have to accept a $20 voucher for legal services. People don't have to accept a power of attorney. As a matter of fact, if any snowbirds are listening to your program, the first stop they should make when they go to Florida and Arizona is to either a notary or to a lawyer to get a new power of attorney, even though they might have made one last year, because powers of attorney are not valid in Florida and Arizona unless they're A, made in Arizona, and B, within 18 months. Every power of attorney that you have, if you bring it to if Dad becomes incapacitated or needs to act on the power of attorney, if you bring it to a bank, the first thing that happens, it gets emailed or faxed to some bureaucrat down in Toronto who may or may not accept the power of attorney. Maybe he or she is having a bad hair day that year, or just for some reason doesn't want to accept that power of attorney. There's no way you can force the bank to do it, and I've run into this directly myself. Quite frankly, not with Pat Murphy powers of attorney. Mine are heavy duty, and I deal with seniors all the time. I'm pretty well known around here.
So power of attorney then for finances, healthcare decisions, like all of that. So you're recommending that be regularly reviewed and
I recommend to my clients to forget about your wills and powers of attorney for 364 days a year, but I say review them one day, or I even tell them a day. November 11th, Remembrance Day. We all know Remembrance Day. What happened last Monday? Woke up, was a nice, bright, sunny day. By 11 o'clock, some poor widow had to put a wreath on the cenotaph, freezing rain. And you just know it's a dreary day. Plug in 45 minutes on your microwave. Don't answer the phone. Don't take the dog out. Don't answer the door. Just spend 45 minutes looking at your documents and then forget about them for the rest of the year, because that's a good time to. And that's why we call November Make a Will Month. The lawyers have been calling that for years, and it's a good opportunity for me to. Again, thanks for bringing me on your show today. I'll be making a few other presentations during the month of November to encourage people to get their affairs in order, because I see the other end of it. Most people come in with a mess. It's nothing for me to see somebody come in with 6 bags of paper.
So how do you eliminate that mess?
Well, you hire me. And it's very easy. All I require is there's a very brief form. I hate filling out forms myself, and so do my clients. And my clients come in and I have to diagnose before I prescribe. Quite frankly, my clients sit down in front of me, they're pretty nervous. They feel coming into a lawyer's office the way I feel coming into a dentist's office. And I just say, well, give me a bird's eye sketch of your family. And that goes on for about 20 minutes, and that gives them a lot of comfort that I'm really listening, and they can tell by what's coming back. And I find out the ups and downs, and after listening to their situation and reviewing the situation, I'll make a recommendation. They might say, no, that doesn't make sense, goodbye, and they don't get a bill, because there's usually a free consultation with the lawyer initially on this type of field. Or they might say, yeah, that sounds good, but hey, we want to see the documentation. The next meeting, they look at the documentation after they've had the initial plan, had some time to think about it, come back and see that if the documentation carries out their plan, then it's they sign it and they're off to the races with this family will planning process, with their affairs really in order.
Okay, so we're going to come back after this short break, and we'll continue the conversation with Patrick Murphy, counselor at law. Thanks. Welcome back to Aging in Ottawa. Today I'm speaking with Patrick Murphy and about important legal issues for seniors: wills, powers of attorney, and probate. So we haven't touched on probate. What's probate and how do you prearrange it?
Well, probate is literally proving the will. If, for instance, I wanted to buy a cottage of somebody who died last summer, how do I know that the person who's signing the deed to that cottage to me is authorized to do that? They have to probate the deceased person's will. So it's just a question of proving the will, and there's a process that the lawyers go through in court to do this. But pre-arranging your probate is something that we're strongly recommending now for a couple of reasons. First of all, a lot of people pre-arrange their funeral. My funeral's pre-arranged. My kids are much too busy to be worried about my interment plans and things. And the way I drive Bonnie, it could happen a little sooner than with a lot of other people. But we're recommending that people pre-arrange their probate because there's some laws coming down the pipe. I think we know that in Toronto there haven't been too many laws passed in the last year and a half. There's been a lot of scurrying around, but there are regulations that the lawyers have been waiting on for about a year and a half that are going to significantly increase the difficulty of the process of getting probate. Yes, it's another tax grab by the Ontario government. But when that comes down, what we're literally arranging is not only do our clients organize their affairs in something I call a comfort book as part of this family will planning process, but that they literally pre-fill in their probate application when the forms are promulgated. Again, this will make it very easy on the people who are taking over the estate, which are usually family members, and gets rid of the lawyers very quickly. You want to get the lawyers out of there very quickly because lawyers are very expensive. And we've heard of estates not being completed for 6, 12, 18 months, 3 years. A lot of the files stayed open much longer than they really should. You want to make it as easy on people that are following you as possible.
You mentioned earlier about the family dynamics, trying to get a sense of it, and we know families are changing. So what about second, marriages, cohabitators? What are some of the things that they need to do to protect their assets?
As lawyers, we know that the vast majority of people who are cohabiting in second, third, or fourth marriages just aren't aware of the laws. They think somehow that after some magical period, a year and a half, 3 years, that, we're treated just like Fred and Mildred next door who are married. That's not the law in Ontario. If you're married, you have significant, powerful rights arising out of the marriage that you don't have out of cohabitation or a second marriage. So you better get your affairs in order with somebody who knows how to deal with your affairs so that the survivor won't get all of the assets. I think most people that go into a second or third marriage want to allow the surviving spouse to use the assets during his or her life, but when the second spouse passes away, I think they want the assets to go back to the first family. We call that a first family trust marriage. It's not really that difficult to do, but it's something that is topical.
Yeah, so definitely can get very complicated.
And it is complicated, except that I'm going down to visit my son in Connecticut in a few weeks. It's very complicated as to how they're going to fix my car up, to test it to see if it'll make it there and back. But to them, they have their diagnostics. You have to go to a specialist, I think, to help you get through that. My clients don't find it complicated. One of the other things in my family will planning process is that my documents are readable. I tell my clients, surprisingly enough, Bonnie, if you don't understand the wording of this document, don't pay me for preparing it. Yep. One of the biggest challenges I had in creating my trademark family will planning process was that the documents are actually readable. I get calls on Friday at 4:30. Dad's very sick. Where are his documents? Or they might have pulled them out and want an interpretation. I have to anticipate that the way things happen on weekends and things, the way, I don't know about you, but I always get a toothache at 9 o'clock on a Friday night, that they can read the documents and have a good idea of how to navigate through them.
So we've talked a lot about particular things around wills, powers of attorney, and probate. So if you were to have a young senior in front of you, what are the 3 things that you think they should do to give themselves and their families peace of mind?
Well, I think that they should consider wills that are maybe a little more dramatic than the ordinary wills, maybe containing some testamentary trusts for the surviving spouse and the surviving children. Another thing that they should have is some backup documents. It's one thing about to give a power of attorney to my son, but do you not think it might be a good idea to write some notes as to how I want my wishes carried out? We call it a living will, and I provide my client with the type of things that I may or may not want to happen in a living will. How about the end of life decisions? I've lived a pretty full life. I've been around for a while, and I'm not in the tender years of my life. I want to leave a healthcare directive for my children to give them an idea of what kind of treatments I want during my period of terminal morbidity. And I back all of that up with what I call a letter of wishes. It's not orders, but wishes. I want my snowblower to go to my friend George, or in my case, I'm a hockey bum. I want money spent out of my trusts and under my power of attorney for my grandchildren who go to hockey school. That type of thing. You can control that with your own documents in that regard. We don't put all of that stuff in a will anymore.
So,
and secondly, with the powerful attorney, make sure you have a valid power of attorney that's going to be accepted by somebody, and we have some strategies for that too. And last but not least, I just think it's a good idea to pre-arrange your probate. I was at a wake last night for a friend, and I know the family had peace of mind. They were focusing on grieving, which they should be, rather than, oh my God, we have to see the lawyer next week, and where is Dad's bank account and all of his affairs and things. You want to get things through the legal process as quickly as possible. Well, take control of it yourself. Only Dad knew what his assets were, and the Canadian culture is that most of us don't discuss these things with our children.
Yeah. So what I'm hearing is, take care of it early on, pre-plan, take control of your assets. Customize it so that you're making sure your wishes are known. We are all out of time for today, and I know I could learned a lot today with you, Patrick, and thank you very much for coming. For further information, you can consult his website at murphylaw.ca, or you can contact him directly for that free consultation to review your will and powers of attorney. Join me next time where we explore accessing health and social services information in our community right here on Aging in Ottawa. Thanks.